Please be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSC Global, there is a link to the website in the description of this video. Thank you.
Hello, everyone, and welcome to today's webinar, Best Practices for Partnering with the State Attorney General During a Cyber Investigation. My name is Tariq Hopkins, and I'll be your moderator.
Good morning, everyone. My name is Ian McConnell, and I am the Chief Risk Officer and Deputy General Counsel at CSC. Certainly appreciate you all making time for us today. I wanted to quickly introduce our panel. Today we have Jerry Stegmeyer, partner with Reed Smith, Owen Lefkin, the Director of the Fraud and Consumer Protection Division for the Delaware Department of Justice, and then Associate General Counsel Helena Ledick. I helped put this panel together to a couple months ago, and know Jerry and Owen quite well. Owen and I worked together at the Delaware Department of Justice under then Attorney General Beau Biden, and we worked on a number of high-profile matters, one probably the most prominent being the multi-state residential mortgage-backed securities settlement with the 50 attorneys general and the federal government. And then Jerry and I got a chance to work together relating to actually a cybersecurity incident that happened at CSC in 2017. And Jerry was instrumental in navigating our company through that experience and has been a tremendous resource to CSC for a number of years. So that's why we're all here, and we're very excited to be presenting to you today. And without further ado, we'll kick it off with our agenda.
And actually, this is Helena speaking. Before we get into our agenda, this is just our reminder that the presentation is not intended, nor should it be used as a substitute for legal advice or opinion, which can only be rendered for specific fact situations. And of course, the views expressed by our speakers today reflect their personal views and do not necessarily reflect the official position of CSC, their government agencies, or their law firms. And today's agenda we've put together for everyone is we're going to be going through a few different areas: evolving enforcement trends and risk, the reasonable versus perfect, and the enforcer's dilemma, incident response basics, risk management, hindsight, and inevitability, the Attorney General offices, paths to partnership in crisis and beyond, and effective relationships with the Attorney General offices. And then we'll also be going into a Q&A session at the end. So we're going to get started off now with the evolving enforcement trends and risk, and we'll be hearing from Ian.
Great. So, Jerry, I think this is an area for you to sort of jump in here at any given moment. But the general gist of this is that the regulatory landscape here is broad. If you look at this slide briefly, you can just sort of see some of the federal agencies that have a stake in cybersecurity matters. I know everyone on this call is probably aware of the recent executive orders that have come out of the White House, which is another component to this whole area. But the number and variety of regulators, both at the state and federal level, are numerous. And Jerry, I obviously take it away and feel free to opine further on that.
Yeah, sure. So what we tried to do here is just highlight some of the biggest ones and some of the roles that are evolving over time. And on the bottom, we have that European Union flag. And so with Brexit and for companies that are multinational, what we're really just trying to get across to people, the chessboard is increasingly complicated. And the Securities and Exchange Commission has been even more active and involved in regulating this space directly, which has a lot of relevance for corporate governance and a lot of derivative litigation that we're increasingly, and shareholder litigation that we're increasingly seeing, filed in Delaware. So, the thing we really want people to sort of understand is we're going to focus today on a very specific area, which is the Attorney General relationships and crises and cyber investigations. But what I want to make sure that everybody understands is, if you only have a hammer, everything you see is a nail. And there are lawyers and resources and folks who have really, really deep experience in, let's say, these agencies or, different places. but it really is a team sport, and we hope that that comes across in the presentation. And it is a team sport because of what we were just talking about, which is to say, all of these agencies are different. They have different ways that they practice. I have 5 investigations going on right now at the Federal Trade Commission myself, and that's just one part of my practice. So that's what we're trying to sort of convey there. And I think that Owen's going to take us to the next slide and talk a little bit about state AG enforcement specifically and the activity of state AG enforcers.
Yeah, thanks, Jerry. And really, we should have another slide in there, right, for the purposes of this presentation with 50 state flags on it, right? Because at the state level, you do have privacy breach statutes in nearly every state, and then those are largely enforced by state attorneys general. And now, obviously, you've had the California Consumer Privacy Act, in place for a number of years. You've got Virginia now. I think Colorado just passed a comprehensive one as well. So you're beginning to see increasing numbers of states with comprehensive statutes beyond simply breach notification statutes as well. This slide here is just sort of contextual for sort of highlighting some of the big settlements that we've seen in AG enforcement in the past, 6 years we're looking at. Obviously, Ian mentioned at the beginning the national mortgage settlement, which was a $26 billion settlement back in 2012 that we worked on together. But the idea here is that there are these are large settlements. They are large problems. Some of them relate to privacy-related issues. Others are more consumer-focused. We've got 2020 here in 2021. You can anticipate seeing. We already had the McKinsey opioid settlement that happened in 2021, and you can anticipate seeing a lot. Probably a number more opioid settlements. For the future version of this slide with numbers in the billions. Probably the most relevant of these for today's discussion is the Equifax settlement in 2019. That was, as it says, it's a $650 million settlement where $175 million of that was a payment to the states and $475 million of it went to consumers. That settlement was a settlement between Equifax and 48 states plus the District of Columbia. Importantly, it didn't include all 50 states. It left out Massachusetts and Indiana, who had filed suit separately, and who subsequently settled for greater than their share that they would have gotten as part of that national settlement. That's an increasing trend that we're seeing. That even in these large multi-state cases, there are, and there will continue to be, states that break off and don't participate in the large settlements and pursue their litigation. I think that something like the opioid cases that you're seeing right now, with so many states litigating, it's reasonable to anticipate something like that may happen. And if you're in the situation where you're trying to work on a nationwide deal, certainly, companies these days are trying to figure out ways to incentivize broad participation from as many states as possible. Another trend, that we're seeing is increasing use by state AGs of outside counsel. That's something that obviously is happening in the opioids context, but we've seen that as an increasing trend over time as well. I think the next slide, we're going to go over to Jerry. Thanks so much.
Yeah, perfect. Thanks, Owen. So just to throw in a bit of levity, I came across this postcard in Arizona. I said, wow, I've got to take a look at this. And in a nutshell, this is both about AGs and responding to cybersecurity investigations. And usually those investigations result from a crisis. And, first and foremost, our role and task is to make sure that the board of directors doesn't look like this one, right? And No one wants to be perceived as, a jackass. And yet when we look time and again across investigations, and in the materials is an article that I've written on corporate governance issues across all of the various enforcement vectors, one of the things we see is that officers and directors are getting caught aware and are seeing, personal liability and claims against and about them, specifically in connection with these cyber crises. And I think Owen's prior slide sort of highlights where some of that comes together. And I know Owen will give some great color, as will Ian, on cooperation amongst and between the AGs. And I just want to echo one of his comments sort of about outside counsel. When it came to Reed Smith, the big draw for me was that we have a very rich state AG practice. And, it's not just the 50 states, it's the states often, working together and not working together, and those dynamics and the relationships. And so that's a good example of how this is, a many-faceted hydra for a lot of companies. And I would call attention, one thing, to the Equifax settlement, which is that, these pieces are often working together. So the Federal Trade Commission often works directly with the states, and they have very active cooperative relationships. So just because the state closes its investigation, it may very well be because there's been a arrangement worked out amongst competing multiple law enforcers. And that's a dynamic that's really difficult to see from the outside if you don't do this every day. Next slide, please. So these first couple of slides, whether it's the jackasses on the board, and that's, not something literal, I'm referring to slide 7, or this slide 8, are really intended to sort of highlight not only where the threats come from, but what the consequences are of those threats. And Owen did a great job of highlighting, some financial cost-specific, penalties. But slide 8 really highlights something slightly different that I think is an important consideration, which is there are vast distinctions between the direct costs of cybersecurity incidents and indirect costs. So, when you think about sort of, prominent ransomware incidents recently, and, a ransom was paid, but the loss in confidence in a company, or the impact to share price, or the customers and brand reputation injury often are difficult to calculate or sort of see, directly. And some incidents matter little, and some matter, a lot. But I think the most important metric for our audience in terms of thinking about those numbers is when you see the amounts that Owen highlighted on slide 6, those are only the direct costs. So, for example, a prominent Minnesota retailer, saw its stock drop, I think, by more than 10% in Q4 at the height of the retail season in response to a very large data incident that they encountered. We've seen this in hospitality. There are a number of industries where it's much easier to see how the indirect costs manifest themselves, and especially when we think about, imagine the distraction to a business when the CEO has to go and testify before Congress repeatedly over these kinds of issues. So we want to just sort of set out, not only some sense of, what the costs are and where they come from, but also to help give you sort of a sense of magnitude and understand this is a multifaceted environment. And we'll move into the next agenda area now.
Jerry, and I would
Yep. Go ahead, Owen.
Oh, sorry. I was just going to say, to sort of add to Jerry's comments on that slide, right? I didn't highlight on the previous slide, we were focusing on financial, but, all of those settlements have injunctive terms too, right? And there's a real cost that comes with injunctive terms that, are often sort of, reflective of best practices of what companies should have been doing, but, they are probably, belt and suspenders on top of what the company could have been doing had they, had the incident not happened. So I think that's part of the cost landscape as well.
It's a great point, Owen. I'm familiar with one very large matter where I was told by some outside consultants and law firms that they estimate the direct 10-year compliance cost of an underlying order is $1 billion. So that's the direct cost of order compliance over a 10-year, that's the forecast. So, and we're seeing in financial statements, businesses specifically reserve very large amounts against, basically not only those financial settlements, but being able to walk the walk and the talk the talk, as AGs and others expect. It's a great point, guys.
So without doom and gloom, I think well stated. The only thing I'd say to this is that it's not a foregone conclusion. In other words, if you manage whatever incident you have proactively, you're prepared for it, you have the right representation, the right advisors and plan, you can avoid a lot of these costs obviously with a lot of effort. But it's not a foregone conclusion that you're going to be jammed up like this. And if you do a bunch of forward planning practices, rehearsals, and connecting with the right resources, you can navigate your way through these kinds of issues. That's just one other point.
Well, thank you, gentlemen. And as we go from the doom and gloom, as Ian put it, of the evolving enforcement trends and risks, we're now going to move into reasonable versus perfect and the enforcer's dilemma. So Jerry's going to get us started off with this.
Sure. So this idea that I think Elena and Ian just sort of segued into very naturally is, I'm the father of 3 Eagle Scouts, and one of the things the Scouts often emphasize is being prepared. And one of the best places for us to see for sources of preparation, the kind of things that Ian was identified, are Federal Trade Commission consent orders. And as Owen sort of alluded to, while the state AG orders are often, I'll say, slightly less formulaic, they have similar types of components, which is to say, where penalty authority exists, that's not the only ramification of these settlements or orders and consents. And in cybersecurity, this is almost sort of, blunt or routine now. But we have some pretty good examples of things that, these orders contain to give sort of the bumpers, as you were in a bowling alley, right, to help you keep from throwing a gutter ball. And one is, what Steve Jobs used to say, having a directly responsible individual, or I've heard others say, whose throat do you choke to create accountability for data security? And the FTC articulates this as designating employees responsible. So one of the first things in any investigation that will happen and is, to think about, look around that sort of nose game, who's ultimately responsible for data security. And one of the things that has changed is not only is there the Chief Information Security Officer, many organizations have these now, but the reporting to structure, how that ties into the executives, how that ties into the board, are things that are ultimately getting looked at very closely now. On sort of a more operational level, these consent decrees often require implementation of safeguards to protect against identified security risks. And those typically include intrusion, prevention, detection, and response, right? So when something happens, not only can we avoid bad things from happening, but how do we actually respond when they do? And that latter piece is something that's getting considerably more attention. There are some prominent SEC enforcement actions where people had programs in place, but things ultimately still didn't go well. And one of the adages I like to say is, there are going to be good decisions and there are going to be bad decisions, but how things actually turn out on the back end is not necessarily going to be indicative of whether something was a good decision or a bad decision. Ultimately, as with any kid in elementary school, if you can't get full credit, the way to get partial credit is to be able to show your work. And that's where having those reasonable safeguards in place, implementing controls that are appropriate for business data use and sensitivity, and then, frankly, testing, monitor, and adjusting your program. Those are all the elements that will ultimately best help a business defend what it actually did and what actually happened regardless of outcome, and that's where we try to get to. Not sure, Owen, if you had anything you would add in terms of AG consent decrees or enforcement specifically, but I think a lot of folks don't necessarily have that sense of what the AG's powers are or how they exercise those powers in this context that might be helpful to share a bit.
Yeah, no, I think that every state's different, but especially in the multi-state context, there's you frequently see the effort to get broad injunctive relief that applies on a nationwide basis, and certainly if the states are working with the FTC, that follows the sort of FTC formula. But even absent FTC involvement, you're going to see that, and it's gonna focus on the points that Jerry highlighted.
Super. So the next slide, Elena. This is understanding risk, and what I want to sort of highlight is because of the 50-state breach notification laws that Ian and Owen have referenced, we've had a real distortion in the marketplace that's had some, frankly, bad consequences for cybersecurity. And one of those consequences, because of the massive amounts of investments that have been made to protect personal information, and frankly, often personal information that's publicly available, it's created a distortion where there are many businesses that might say have, critical infrastructure or food suppliers or industries that traditionally didn't necessarily process volumes of personal information. In many instances, those are sectors that we find are lagging, and they're lagging understandably because they haven't had these compulsory breach notification laws applying, because if they have a breach or if their business is down, it's a different kind of security consequence. And so we've highlighted sort of three here risk areas. There are competition risk issues, reputational issues, and legal issues. But I think if you look at it and sort of think about it, we've all seen merger activity that's been hampered or undone, or there have been complications. And we see issues sort of with source code or customer data, and this is increasingly where we've seen this explosion in what's known as ransomware. Someone, takes over and locks you out of your systems, and then will allow you back in, if you pay a very large toll, which, law enforcement historically has strongly discouraged, but tacitly acknowledged is often the simplest, cleanest path for these companies. And there's a bit of, if you negotiate with terrorists, you're going to cause a big increase in terrorism, and that's really a recurring problem that we've seen. The next slide that I want to talk to you briefly about relates to sort of root causes. And the goal here is just to help sort of understand, as a baseline, some recurring security governance challenges that we see over and over again. And the first one is, an immature strategy. So your program isn't, repeatable, demonstrable, and sustainable. It's not directionally important. We often see this in programs and companies where they buy lots of widgets, and if you ask the CIO about the cybersecurity program, you'll get an answer that says, I've spent all my discretionary CapEx the last 3 years on cybersecurity. Programs that are focused on measuring the inputs without a strategy are programs that I would characterize in this immature strategy bucket. The second is a lack of skilled expertise. And that is not only at the executive leadership level, but sort of all the way through. So we've worked a lot of cybersecurity incidents, and I've come with sort of an adage that says, a peacetime chief information security officer may not be the best chief information security officer in wartime and when things are bad. And it's a very sort of different skill set, and it's one that, frankly, the executive leadership of many companies would benefit from just being able to ask that question. And for those of you on the call, I would say thinking, especially if you're a general counsel or you report directly to the general counsel and you're trying to think about these areas to ask your questions, right? This is how things run day to day. Do we have the right people in the right place when everything goes to hell? And even the act of asking the question can be very instructive. And we often find ourselves engaged and working with consultants and others where companies have brought us in and asked for sort of an independent perspective on, the team, right? Not just the process and the technology, but who are the people. The third one, missing the full picture, is where, frankly, the business strategy and the security strategy are not aligned at all. And we often have a slide that I used on this, but a simple way to think about it when I say missing the full picture. Imagine the security organization comes along, finds the door, and says, oh, this is not a secure door. We need to put 100 locks on it. And then the next person comes along and they really have to go to the bathroom badly, and it turns out that the door they're facing has 100 locks on it and they need to go immediately. You can appreciate that urgency. And there's no one around who has the keys. Effectively, that bathroom doesn't function at all. That's the kind of thing we, frankly, see often where the security team isn't sort of read into the broader organizational strategy, and the executive leadership isn't aligned in terms of thinking about sort of all of the risks. It's more, ad hoc and less intentional. And what happens with this is a failed program. And I just want to highlight, we have, breaches, it's in the news, or the chief information security officer is fired. But I want to be clear, and I think Ian really brings this out to me, right, in some ways of how he's in the doom and gloom slide. Because you have a breach, that doesn't mean that your program failed. There are only kind of two companies that have breaches, those that have them and those that don't know about them. So having breaches in and of themselves is not indicative automatically of a failed program, but frequency, making the same mistakes twice, having a failed or botched response, very common program. And finally, the CISOs or other executives being fired. I often joke, once I was asked by a CISO and a general counsel about, we were the fourth law firm hired to look at a really difficult situation. And I said, listen, here's how this goes down. There's one thing you need to know. In any large organization, when the historic exercise of judgment is questioned, that organization is going to substitute new judgment, regardless whether it was good or bad. And so for chief information security officers, they often last less than 24 months, sort of for a host of things. But one of the things is being accountable for things that went wrong that often weren't within the realm of their control. And that's exacerbated by that sort of expertise piece and the other things that we're talking about. So next slide, Elena.
Jerry, before we go on, I would just, highlighting your sort of, your point about breaches and that companies either are companies that have breaches or don't know they have breaches. From the enforcement angle, right? I mean, I think that, the AG community has, recognizes that breaches are a fact of life. And it's not breaches that result in enforcement activity, it's the response or the shortcomings of the response. So Jerry highlights failed programs here. From the enforcement perspective, it's really failed responses to the breaches, right? Breaches happen. It's how you respond, and we're going to get into, right, how you engage with regulators as part of that response. So I just want to flag that.
So this is, Jerry, so Jerry said that to me, that exact same phrase, which is, when judgment is questioned after the fact, usually, it's replaced by new judgment. And that's a startling thing to hear, obviously, when you're trying to go through some significant issue in your company. That didn't happen for us. We had an incident in 2017. Won't go into all the details of it, but Our management team stayed in place. We didn't get sanctioned. We spoke to regulators. We worked our way through it without any long-term consequences. And actually, to be frank, we actually are better today because we had an issue in 2017 that caused us to really think about these issues very deliberately. But I take the other sort of side of the coin here, which is if you do the right things up front and are prepared as best you can and do what Owen is talking about, which is to engage, you can the old judgment can remain. It's not a foregone conclusion. I'm sorry, Jerry, I interrupted you.
No, it's perfect. There's one thing, because I obviously like this dialogue, and we have a lot of different perspectives, and the chances are riff off of what you all said. And I would say I've seen real changes in the AG's offices over the years, with both the nature and level of sophistication and the staffing, where things that would get a lot of attention 5 years ago don't get any attention now. And when I say they don't get any attention, if you have rapport and relationships with your regulator or the people who are advising you do, it can be very cooperative and very quick. But the flip side of that, we'll talk about how some of those things happen, but I'm fond of saying you only have one chance to lose your credibility. And that's one of the most difficult areas, depending on the team that you have and how people think, about things. But great feedback, Owen and Ian, and thanks obviously for the kind words. I kind of sometimes say, look, we can't control the outcomes, but we can influence the inputs. And that's really the way to think about this, because Owen's point and Ian's point begs a sort of hindsight question. How are we going to be evaluated? And often we're going to be evaluated, on the inputs. There's this moment in that movie, Black Hawk Down, where the sergeant says to one of the other guys when they're going to go back out, and he says, what you decide to do right now, is up to you. But the way the cinematography works, it's very clear to everyone that, in hindsight, this decision is going to be evaluated. And it's really, kind of a helpful framework to think about those inputs. So super helpful.
So we've heard from Owen, Jerry, and Ian that it's not necessarily that just because you've had a breach doesn't mean that you've had a failed program. It's a failed response. The idea is to be better off from what happens today to build something better for tomorrow, and learning about influencing the inputs so that we can better influence that. And so we're going to jump into that now with some of our incident response basics of how we can end up doing some better influencing. And Jerry's going to get us started with this.
Sure. So slide 15 is just a simple infographic on incident response plan effectiveness. And I like this hub and spoke model that also emphasizes the criticality of outside support and vendors. If you only know your own experience, it's difficult to objectively, evaluate it. And so that there's a real role for outsiders. And these are some of the key folks that we view as, sort of a checklist for folks. But my perspective would be, I'd love to just hear, I've spoken to this slide many times, but Ian, from your sort of direct experience in 2017 or otherwise, what resonates with you in this, diagram, or that sort of, you can't read a book and learn how to hit a fastball. So you've hit the fastball. What's helpful?
Great, Jerry. Yeah, no, I got just two sort of comments to this. I agree with everything that's on this slide. I think this is the right team that you need to be thinking about. I would just add a couple of points. And the first one is that everyone on this call probably has cybersecurity insurance through some insurance provider. I don't know how often you all take that insurance policy out, open it up, and look at the resources that are already designated inside that insurance policy. And that's something I didn't fully appreciate in 2017, how much those panel vendors, they're called, panel vendors, are going to help address an issue, and understanding why the individual vendor has been selected and put on the panel is a really important thing to dig into before you have an incident, not after. For me, I didn't fully appreciate that the crisis communicators specialize. You can have a general crisis, PR firm on retainer like we do, and they're great. They do great response for journalized incidents. But when it comes to a cybersecurity incident, oftentimes you really want that specialized talent, expertise available. And in our case, our insurance policy has a panel vendor that had a specific crisis communications firm that I didn't really tap into until probably 6 months into the actual incident. So that's one thing, is look at the panel vendors on your insurance policy, because that's going to be what your insurance provider is going to reimburse you for and going to dictate what kind of resources are available, and then why have they selected those resources, and maybe you need to augment or understand if you need some additional ones. And to that point, not every outside counsel provides the same type of advice. So we had a firm that provided very specific advice around reporting to attorneys general offices through the data breach notification requirements. Very detailed, very experienced in how to do that. That was great information. What they weren't great at was sort of the strategic counsel that you sometimes need, the 30,000-foot counsel, and that's why, in point of fact, we hired someone like Jerry Stegmeyer to provide that kind of broader strategic legal counsel that wasn't really available from the panel vendor that was designated to help us with the AG response. Not that Jerry's firm can't do probably both, but in our instance, the firm that was designated under our insurance policy was really great at one thing, not great at another thing. And it wasn't until probably 8 months in we realized that, and I retained Jerry to help us with our issue, and it was a huge value add. So I think you need to understand that that there might be different strata of counsel that you and resources you need, and really kind of dig into that before an instance happens, so that you're better prepared for it. And Jerry, I don't know how that resonates with you at all.
No, I think they say we have 2 ears and 1 mouth for a reason, Ian, and any opportunity for people to hear you share what came out of this kind of model is super helpful, and obviously appreciate the kind words. One thing I'd add, just since you focused a bit on insurance, is when you're going to look at those policies, really important strategic considerations. I've seen many companies get hampered where their policies designate, basically those vendor panels, but the vendor panels don't know the business. They don't know the company. And one of the most important things for many companies when making those kinds of purchases is to ensure that they can have the freedom and flexibility to have the counsel that you want, which is your right, but having it as your right versus negotiating it up front when they're competing for your business is a very big deal, including right up to and including rates, because law is not a lot different than many areas. There are Ferraris and there are not Ferraris, and every and there's a role for all of the players, but you want to ensure that you have the freedom and flexibility to pick the right counsel who's best for you, or the right vendors who are best for you, or frankly, to have the people you have and you like already who would be perfect in these roles, but might not necessarily be panel, because those are, a different negotiating considerations come in. So that was great, Ian. Great to hear that. Next slide, please. So I'll hit this slide quickly, and I'll let you all have a moment to just look at it and let it sort of sink in. And then I'll tell you why we have this. So if you look from day one, out to creation of a final forensics report, you'll see that bottom line there is often 60 days. but European regulators require notification within 72 hours. Some state guidance has said within 10 days. What I want to make clear here is forensically, with levels of certainty or confidence, a business often cannot, and I want to be unequivocal, cannot meet standards and deadlines set under relevant law. So a practical legal consideration is, do we have a breach or not? That's a legal question, often depending on the laws of all 50 states and a bunch of federal regulators and Europeans also. Throw into that mix these notification timelines, and what I want to suggest is following the law is critically important as best you can. But if you don't have sufficient factual information to determine whether the law applies, notifying a bunch of people because you're trying to hit the deadline often can be the bad decision or the wrong decision, depending on how one thinks about it. Flipping that around, however, and I used the example earlier, you may very well have enough information to say, well, we don't know all the specifics, but we have a good relationship with Owen in the Delaware office, who is our, Delaware AG's office, who is our local regulator. Maybe that's something we want to pick up the phone and make a phone call, or maybe we want some, communication so that you can manage expectations, because my experience has been many, not all, but many of the regulators are super understanding because it's helpful for them to understand you're trying to do the right thing, but false positives aren't helpful. So a lot of verbiage around this slide, but the key being average time to containment being 82 days, and some regulators wanting, desiring, or demanding notification within 72 hours. And so navigating that as a legal and reputational issue is very tough. Maybe Ian or Owen, you guys want to react to this, but I think it's important.
Yeah. I mean, look, without conceding, the point that sometimes, the law is going to be incongruent with what you can do in terms of your determination. I mean, I think that's a conversation that if you get to there, you'll have with the regulator. But I just want to echo Jerry's point about the early engagement with the right regulator. And that's not to say that it's an opportunity to go regulator shopping, because that can backfire. But identifying, either your home state AG, the FTC, if there's, if you're all over, identifying, an AG office with real expertise in this area. And there's a list later in this presentation about those AG's offices that actually have, privacy units that really have deep expertise that they've developed, in this area. If you, without, regulator shopping, if one of those offices is in your backyard and, they are going to be somebody that you're going to end up reporting to, it makes sense on both ends, both from, preventing sort of, them coming later and sort of catching you for not having complied with the reporting period, but also because you want to draw on that expertise that they have and you want to seek their guidance. And so I think that there is an incredible amount of value, not by, going to the National Association of Attorneys General and sort of blasting something to every AG office, but identifying, a few, one or two AG offices that you can work with, that you can point to, because we're going to talk later also about creating a narrative, right? You're going to tell a story, and part of your story should be engaging early with regulators, because that helps you and it helps the regulators. It helps, when ultimately a multi-state, if it's going to develop, having the lead state on that multi-state be the one that you engage with early is to your benefit. So yeah, I think that's an incredibly, incredibly important point.
And I think the way I would tee that up, right, and it's a variation of the donkeys on the slide, up above, things get sideways in a very simple set of circumstances. When someone in Owen's chair or another regulator is asking themselves, why are we just hearing about this now? And there are going to be times where the answer is you're just hearing about this now for X, Y, or Z reasons, and I've laid some of those out on this slide that we're looking at. But Owen's point is, I think, or it would be my point is, you want to avoid a circumstance where there are surprises and the person whom you're talking to is asking themselves or scratching their head, why are we just hearing this now? Because, we as humans naturally create our own narratives of things, and a common narrative in this sort of circumstances, well, did they just not know? Is there something they're keeping from us? And all of those things beg that question, why am I just hearing this now? Which is something to be avoided. And to Owen's point about conceding the point, I think there is some truth to that adage. Don't worry, we're from the government, we're here to help, which is a perspective from a particular, place or chair. And I think, it's well-intentioned, but often I think on the other side, it may not be as helpful, but flipping it around, it can be enormously helpful for the reasons Owen suggested.
Yeah, and to the point of the narrative, right? So you're going to be creating your narrative, but like the narrative from the regulator, if they get notified on day 82 and they've got a notification day that was 14 days after discovery or determination, right? The narrative there is, it may be, your narrative may be that, we couldn't have possibly, done it within that time frame. But the narrative from the regulator is, that at that point, that's neither here nor there because you could have reached out earlier and started that conversation. That having that conversation be part of the narrative is critical.
Yeah.
All right.
Yeah, figuring out how to navigate those shoals is important.
So we're going to move into our next area, risk management, hindsight, and inevitability. And in the interest of time, we're going to go past this reasonable security isn't necessarily. We're going to move past that one, and we're going to just jump right off into the cybersecurity area and talking a little bit now more about the different breach notification laws and different attorney general actions. Owen?
Sure. And so, and I'll try to go through this relatively quickly. This first bullet here is just, I think it's old news to most people on the call probably, right? We talked about the 50 state breach notification laws. Those have evolved over the years. The definitions are expanding. States are including biometric data. There's always been, for at least the past decade, a push for a federal law that preempts this patchwork to some extent, or at least creates some consistency. That hasn't happened to date. Obviously there continues to be push in every new Congress for that to happen. I think that, the AG community, recognizes that notwithstanding sort of our enforcement prerogative and our state laws, that some consistency at the national level has its advantages. But in my view, as industry pushes for a federal legislative solution here, the key really is to make state attorneys general into allies in that effort. And the way to do that is while providing a national standard, continuing to allow for state attorney general enforcement. State attorney generals as the boots on the ground, that they are often the ones that are going to be your key partners there. In terms of increasing AG proactivity, we've talked a little bit about that some states have these privacy units. It really, the level of engagement in the different AG's offices differs wildly. So, for example, in Delaware, we do the AG enforcement out of our consumer protection unit. In Connecticut, they have a separate privacy unit with 9 attorneys dedicated to just this. As you can imagine, Connecticut is going to be more proactive than Delaware in this area, and so it varies widely. There's also new legislative activity. Vermont data broker legislation. California also, as part of the CCPA, requires data broker legislation. Those continue to evolve. The definition of data broker in those laws varies. The Vermont and the California laws currently exclude companies who have direct relationships with consumers, but you might find that definition of data broker expands with time to include direct relationships. That being said, traditional breaches do still remain a priority in the AG enforcement community, and they're multi-states form when notified of breaches, and we look at, as we said, the responses. That tends to be the focus. One thing I do want to touch on is the role that the False Claims Act can play. And this isn't something that we typically talk about in this area, but I do think that it is a increasing area of enforcement, and therefore risk from the company's perspective. 31 states have False Claims Acts. Some are Medicaid only, but many are coextensive with the Federal False Claims Act, which basically creates liability for false statements or fraud in connection with a request for payment from the government. Increasingly, we are seeing both key TAM suits and state investigations that are not related by private plaintiffs based on cybersecurity certifications. There was a settlement with this note at the bottom with Cisco a number of years ago, where there was actually a subcontractor who had identified a bug in Cisco's software and had brought it to the company's bug bounty program, but had gotten rebuffed and instead became a relator, a key TAM relator. And the underlying facts of that case was simply that Cisco, in its contracts with government clients, had certified the information security of its systems, and the subsequent suit and then settlement resulted from the falsities of those statements. I suspect that if any of your clients have the government as customers, and you are providing some sort of data services to the government, there will be information security, cybersecurity certifications that are made in those contexts, and your contracting folks may not be the same people who are up to speed on the cybersecurity protections, your information security system that you have in place. But there needs to be discussion between your contracting folks and those to make sure that you aren't inadvertently creating False Claims Act liability for your clients in that respect. So that is one area that I don't think has gotten a lot of press, but if you haven't seen it, the Cisco case and settlement is worth a look at for potential future enforcement trends in false claims areas.
Great.
Next slide.
And in the interest of time, I'm going to jump a few slides ahead. And one of the things that Owen mentioned just a few moments ago was that some of the states had some privacy units here that were a little bit more specialized. And we can see those you can see Arizona, California, Connecticut, Florida, Illinois, Indiana, New Jersey, and New York. And probably as we're speaking, more are being formed. So what we're going to do then is...
Sorry, Helena. I would just add Massachusetts should also be on that list. They created one about a year ago.
Terrific. And then our next slide, what we want to talk a little bit more about is what do the attorney generals focus on? So some of these examples of inquiries and letters. So Owen, if you can take us into that.
Yeah. So in addition to attorney general enforcement, right? The attorney generals are also active in the advocacy area, or in the short of enforcement, sort of the inquiry area. And so these are just some examples of areas in which there have been multi-state letters or inquiries to companies that have been publicized. So in 2020 there was a 39 Attorney General letter to both Apple and Google expressing concern about contact tracing apps' privacy implications and asking those companies to take action with respect to consumer privacy and contact tracing. The Social Security Administration was a 2018 letter by 43 Attorneys General asking the acting commissioner to prioritize the implementation of a new database system to meet congressional requirements. The Equifax, that was a separate and apart from the data breach and settlement. In 2017, 34 attorney generals wrote and published a letter to Equifax expressing concerns over conflicts of interest, where Equifax's own credit monitoring service was being promoted in the context of their breach response. So that was separate and apart from the settlement. Next slide.
For folks on the call, I mean, in this day of hyper-partisanship, you don't very often hear 50 states all advocating for the same thing, or 39 states. And we have obviously Republican and Democratic attorneys generals out there. But these are issues where there's broad consensus across party lines, and it's a force to be reckoned with. So, the AGs have always been, interested in influencing policy and being using their bully pulpit, so to speak, to advocate. But I think it's worth highlighting that these are really bipartisanship efforts that have a lot of sway in the federal government, and how regulators think about these issues, and how legislatures and the federal government think about them as well. So just something worth highlighting.
And in our last few moments that we have together, we're going to do the rapid fire, the effective relationships with AG offices. And Owen and Ian have alluded to a lot of these already as they've been speaking, but we're going to go through a quick rapid fire of best practices.
Yeah, so I'll take this slide here, and Owen and Jerry, please feel to chime in, and I won't read every bullet point here, but the bottom line is engagement. You don't want to, the first time you talk to an attorney general office shouldn't be after something bad has happened. It should be proactive. You should designate somebody in your organization that can build good rapport, to go out and actually meet with the AG's office proactively. That could be just coming in and introducing yourselves. It could be on a specific issue that's important to your company. But a proactive engagement before an incident is critical. The only other thing I would point out here on all of this, and in my prior life as a deputy attorney general, I ran two of the divisions in the Delaware Department of Justice, and I was at one point the chief deputy. And so this chain of command point that's on this slide is important for folks to be aware of. Use the chain of command when possible. Nobody. If you have an deputy attorney general or assistant attorney general reach out to you, nothing's more sort of disheartening or almost prejudicial than trying to jump the chain of command to go right to the attorney general, him or herself. Try to work your way through the chain of command when possible, and only escalate if it's an absolute must. And I felt like that's something that maybe Owen can react to.
Yeah, no, absolutely. So I think, again, it depends on where you are in sort of the arc of a case. If there's an investigation that's been started and it's ongoing, jumping right to the front office, to the attorney general, and sort of blindsiding the staff attorneys is never going to help, unless you are going because you really think there's been some sort of ethical violation that you simply can't make progress on that with the line attorney. But short of something like that, I mean, the attorney general is going to be fully briefed by their staff. They'll get the outreach. And if they agree to a meeting, that they will get a full briefing beforehand, and you will not win any friends, and certainly won't win the attorney general by blindsiding a staff attorney. And so it's always best, like Ian says, to use the chain of command if possible. Now, to Ian's other point that, if you want to establish the relationship early before there's a problem, one of the big trends, over the past decade has been increasing sort of access to the front office before investigations start. A lot of companies reaching out, giving briefings to Attorney General or senior staff, before an investigation is even started. That is, I would say it's a mixed bag in terms of whether that's a positive development or not. It can often, it can present challenges from an enforcement perspective because it puts something on the radar in a way that it might have developed differently, but it also, makes sure that there's front office awareness. The key to those is making sure that, if you are reaching out to the front office sort of pre-investigation, recognize that in those meetings, sometimes having staff there who understand the issues, in addition to the Attorney General, or sometimes in the alternative to the Attorney General, because frequently the outreach will be made and staff will be asked to take the call. That's to your benefit. Not getting the Attorney General is not always a bad thing because, it preserves the opportunity later on for escalation as well and doesn't wear out that welcome.
Owen and Ian, there's 2 bullet points on this next slide that I think are really phenomenal to talk about, and that time isn't necessarily on your side, and be aware of the asymmetries. Can you 2 really address those 2 bullet points?
Sure. Yeah. Sure. No sweat. So, the first thing is the reality of it is that as an Attorney General office, they're not thinking in months. They're not thinking in 6 months or quarters or annual reports. They can literally conduct an investigation for years, and they're not subject to the same pain points around cost that a private company is dealing with. So you just sort of have to understand that they can literally outlast you and just sort of drive you into the ground. So best to try to understand that that's the dynamic you're dealing with, and look to try to efficiently resolve something early on if you can. Just because trying to outlast them is generally a bad idea. I bet you right now there are matters that are still pending in the Delaware Department of Justice today that were active. I know they were active when I was in the office almost 10 years ago. So that gives you some perspective there. And then the asymmetries. We've already sort of raised this point in the concept of injunctive relief. But you have to keep in mind that Attorney General's offices are political in nature in some respects. Not every Attorney General's office is the same, but most are elected throughout the country. And so they are going to look at monetary settlements as a way of keeping score. Like we got a strong monetary settlement for our consumers or for the victims, and that's a way of demonstrating that someone was being held culpable. But they're also going to be looking at the injunctive side of it. They're going to be looking at it from a public safety best business practices perspective, and are going to be looking for some sort of injunctive relief that makes the situation better going forward. And that's going to be an important component to any resolution. And in some ways, it gives a company an opportunity to explore injunctive relief proactively within the Attorney General's office, understanding that dynamic, and maybe balancing that off with a lesser penalty. And Owen, I don't know if that rings a bell or not with you.
Yeah, no, absolutely, yeah.
So I'll just throw on to that. I know we're just about out of time, but one of the things in those things that you just sort of described, Ian, is a real opportunity for outside parties to be creative, understanding the incentives and motivations, and being willing to ask, of the AG and the staff. That's something that I found to be a little less obvious to outsiders.
Yeah, and the other thing I would say is that last bullet on this slide. It's the public optics and disclosures are important, and keep in mind that the staff in the Attorney General's office don't get paid any more just because they brought in a $1 million settlement. Their payment is often, doing the right thing and getting recognition for it. And that can, that you should be aware that that can drive folks, and making sure that there is, public awareness of the work and of the corrective efforts that the AG's office has achieved through a settlement. So that can be important to keep in mind.
Thank you very much. Well, folks, I think we're pretty much out of time for today's presentation. And with that, I'd like to really thank Tariq for getting us started off, and then the expertise of Jerry, Owen, and Ian, who have all gone through this from different perspectives. Ian, who has had the opportunity to work with Jerry on an incident that CSC had, learning what goes well and what doesn't go well, and to know that not everyone is going to be your best resource for everything. And then also the perspective of Owen, who brings such a great perspective of knowing how that Attorney General's office works, and how to partner with them, knowing that time isn't necessarily on our side, and knowing about the optics of things. And with that, thank you very much, gentlemen. I'm so delighted that you could join us. If you had any questions, we'll follow up with you afterwards if we were not able to answer them today in our remarks.